All right, we'll go on the record, Didi. We're now live on YouTube. My name is Judge W.C. Kirkendall. I'm presiding by assignment in the 25th Judicial District Court. I'm calling the hearing to order in cause number 19-1245-CV, styled Guadalupe County Groundwater District versus Posto Clean Green, Inc. The date is Wednesday, February 3rd, 2021. All right, go on the record, Didi. We're now live on YouTube. Let me fix that. My name is Judge W.C. Kirkendall. I'm presenting. We get an echo if I don't close the web browser. All right. This hearing is being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted other than by the official court reporter. Any violation of these instructions are punishable by contempt of court. Please mute your microphone and only unmute when you are speaking. Please do not speak over other participants. If there is an objection, please state objection, wait for the speaker to stop or for me to stop them, and then briefly state the basis of your objection. During this hearing, please do not use the chat option on the options bar unless the court grants permission. If anyone needs to have a private attorney-client conference or a sidebar conversation, you may ask to be placed in a breakout room for a private conversation. Since these are non-evidentiary motions, I assume there are no witnesses and we don't need to go over the rule regarding the exclusion of witnesses. All right, we'll begin. I want to make a couple of prefatory remarks. I'm sure, as everyone knows, I've previously ruled on what I understood to be this same issue. That ruling was reversed on, let's say, not on the merits by the fourth court on the issue of ripeness. So what I'd like, I wondered why I was appointed to this without objection, and I can only assume that it's because everybody realizes this will be resolved in the appellate courts, and what I do here today will be little noted nor long remembered. But I'd like to know, the two things I'd like to know is, number one, what's different? Why should I change my ruling previously, if I should? And second of all, why is ripeness not still an issue if the an appeal of the TCEQ ruling is currently pending in Travis County District Court? Or are the defendants waiving ripeness as an issue so that we can proceed to the merits of this case? Those are the two things that are primarily of issue to me today. I've reviewed my previous ruling and the petitions answers, intervention in this case. I think I have a reasonable understanding. I guess, Ms. Perales, you're the plaintiff. I'm going to let you go first on the motions. You may proceed.
Thank you, Your Honor. I'm Marisa Perales. I'm with the law firm of Frederick Perales Allman and Rockwell, and I'm here on behalf of the plaintiff, the Guadalupe County Groundwater Conservation District. And before I get to the main argument, to the main points I'd like to present to the court, I would like to take up the two questions that you've presented first. The ripeness argument. The ripeness has not been raised in this case, and part of the reason I believe is because in the previous matter, TCEQ had not yet issued a permit, and that was ultimately the linchpin of the Court of Appeals opinion in determining that the case was not right. The Posto Clean Green Inc., the landfill permit applicant, could not move forward with construction or operation of a landfill without a permit from the TCEQ. Now the TCEQ has issued a permit. While that permit has been challenged under the Administrative Procedure Act in the Travis County District Court, that does not prevent the permittee, Posto Clean Green Inc., from commencing construction and operation of the landfill. And in fact, it has already commenced construction of the landfill at the proposed site.
I would
So
object to counsel testifying, but there's an issue of her giving factual evidence to the court right now that I don't think is before the court.
All right, we'll proceed, Ms. Perales.
thank you. And the difference, I think that the difference between the prior case and the issues presented to the court and this case are reflected in the pleas to the jurisdiction and the responses to the motion for partial summary judgment. The main issue, the main question presented to the court remains the same, and that is whether the Solid Waste Disposal Act preempts the groundwater district from implementing and enforcing its local rule 8.1. The difference is that the TCEQ and Post Oak are now relying upon the final order that was issued by the TCEQ granting a permit to Post Oak Clean Green to bolster its argument that TCEQ has the final say. So while the TCEQ's final order kind of took care of the rightness argument, in TCEQ and Post Oak's mind, it bolstered their preemption argument. And that's just kind of my take on their arguments. I'm sure they'll elaborate further if I've mischaracterized anything here. But that's the difference as represented in the pleadings. As I mentioned, I'm here today on behalf of the Groundwater District, which is a democratically elected groundwater district, and it is charged with conserving, preserving, protecting, and recharging the groundwater within the district's boundaries. It's also responsible for preventing degradation of water quality and to protect interests of those who use the groundwater. And so the district has implemented certain rules to achieve the objectives as authorized by state statute. And one of those rules is Rule 8.1, the rule that is the crux of the claims that are before you today. And basically that rule, Rule 8.1, says that waste or sludge cannot be applied in any manner over the outcrop of the aquifer within the district boundaries. And the rule has been in existence now for over 20 years. As I mentioned, this is the subject of our lawsuit, Rule 8.1, and it is the subject of our motion for partial summary judgment. And it was the subject of the prior lawsuit and the prior motion for partial summary judgment. So in short, this particular case presents the question of whether this democratically elected groundwater conservation district has the authority to implement and enforce rules that limit certain activities, such as the proposed landfill here, for purposes of protecting the aquifer and water quality within the aquifer, which the district is obligated and responsible for protecting. Under the Declaratory Judgment Act, we're seeking a declaration as to the construction of the rule and the rights of the parties under the rule. TCEQ and Post Oak have presented this court with arguments suggesting that the case is about landfill statutes and about landfill permit regulations, and that TCEQ therefore is the only entity with the authority to regulate landfills. But this case is not a challenge to TCEQ's landfill permitting authority. Again, the case is about the district's Rule 8.1 and whether it has the authority to enforce it. So you have before you today both pleas to the jurisdiction and our motion for partial summary judgment. And in some ways, these pleadings, the pleas to the jurisdiction and the motion for partial summary judgment, are related, inextricably related. So before I get into the arguments related to either of those motions, I'd like to lay out a couple of basic facts that are undisputed and that are relevant to our case.
Your Honor, I'm sorry, I don't mean to interrupt Ms. Perales, but are we arguing the motions now? Your Honor had a couple of discrete questions that you asked, and now seems that we've transitioned into Ms. Perales arguing.
Well, I
Yes.
told her to go ahead, but Mr. Riley, your point is well taken. Ms. Perales, my memory is not what it once was, but I think I heard most of this 5 or 6 years ago.
Yes.
And, you know, just I really don't want to reiterate a lot of that. I understand it and recall it. I want to know what's different now. I mean, is there some, has the legislature changed the law? Has TCQ done something different? Is there, I think the issue was implicit preemption previously. Is there something that the defendants are arguing that is different than the argument that was made? And do you have a counter to that?
Sure. Thank you, Your Honor. I will restrict my arguments to that
It
question.
might be that it would be good for Mr. Riley and Mr. Steinbach to go first, and then you could respond more easily, since you were the prevailing party last time in my last order, and they could allow them to slice and dice my order and tell me what I did wrong or what's changed. Mr. Riley, why don't we do that?
Okay.
Yes, Your Honor. And I'm going to defer initially to Mr. Steinbach, if you don't mind, Your Honor, and let him go first, and then I'll address the issues after Mr. Steinbach, if that's acceptable.
Sure. You're muted, Mr. Steinbach.
Got it. Thank you, Your Honor. First, I would like to actually admit what we had provided the court as Exhibit 1, and that is a copy of TCQ's final order on the application from Post Oak Clean Green Inc. To operate a municipal solid waste landfill.
I'm going to take judicial notice of it since it's an order of a state agency.
Okay. Well, Your Honor, in answer to your questions, I guess I'll start there. What's different? I think Ms. Perales basically stated it correctly. What's different is now there is a final order that has been issued on this matter, and that order is an impediment to this lawsuit going forward.
Mr. Steinbach, do you agree that ripeness is no longer an issue?
That's correct, Your Honor. I think that the problem with ripeness was the fact that TCQ had not yet acted on this matter. So now what we have is a problem based on exclusive jurisdiction and the attempt at a collateral attack on what is now a final order. And that's why this case is different from Your Honor's previous handling of this. Basically, as we see it, there's three problems. TCQ has exclusive jurisdiction over the siting of a municipal solid waste landfill, and that includes the fact finding that it must make as part of its ultimate decision. Second problem is the district suit is a collateral attack on TCQ's final order granting Post Oak's permit. And third, the suit is barred by the redundant remedies doctrine.
Barred by
the redundant remedies doctrine.
Oh.
And Your Honor, because there has been a permit issued in this case, I thought it would be helpful to provide some background on the permit proceeding before going on. As you know, Post Oak applied to TCQ for a permit to construct and operate a Type 1 municipal solid waste landfill in Guadalupe County. After passing the agency's internal review process, a public comment period, an opportunity for public meetings, TCQ referred the matter to the State Office of Administrative Hearings, which we call SOA, for a contested case hearing. The district, along with other interested parties, participated in the SOA hearing and had the opportunity to present evidence and objections on the proposed landfill. The SOA proceeding was an exhaustive process with multiple hearings that spanned the several weeks. The presiding administrative law judge took evidence on all the contested aspects of Post Oak's application, including the subsurface geology and hydrology of the proposed site. Numerous geologists and other experts testified as part of this hearing. And ultimately, the administrative law judge determined that Post Oak met the requirements for a Type 1 landfill permit. The LJ then issued a proposed decision in two parts that contained over 400 findings of fact and over 100 conclusions of law. The commissioners of TCQ adopted this proposed decision with some modifications in a final agency order. And in that final order, TCQ specifically found that the location of the proposed landfill is on the outcrop of the Upper Muddy Wilcox geological structure. And it further found that the Upper Wilcox functions hydrologically as a low permeability aquitard. Now, the district believes that TCQ's geological findings here are incorrect and that the proposed landfill is on the outcrop of the Carrizo Wilcox aquifer. And they naturally filed a suit for judicial review of that final order in Travis County District Court, and that suit is currently pending. The district also brought this suit seeking a declaratory judgment under its Rule 8.1, which you're already familiar with. So basically, the district seeks a declaration that Rule 8.1 prohibits Post Oak from constructing and operating its TCEQ permitted now landfill. So the first problem is essentially its exclusive jurisdiction. That the district is seeking a declaration on a matter committed to TCEQ's exclusive jurisdiction. The legislature has given TCEQ exclusive jurisdiction over the management and permitting of these landfills in Texas. And the district here is attempting to avoid the jurisdictional problem by focusing on the form of relief it seeks. That is, a declaration on the applicability of its rules. And we do not claim, as the district suggests, that TCEQ has exclusive jurisdiction to determine whether the district's rules apply. Our complaint is with the substance of the claim. The district cannot use its rules to interfere with a matter committed to TCEQ's exclusive jurisdiction. So the requested declaration here would interfere with TCEQ's authority over the siting of landfills, and it would also interfere with TCEQ's authority, fact-finding authority, over the proposed landfill in this case. So the basis for TCEQ's exclusive jurisdiction is set out very clearly in the Solid Waste Disposal Act, which establishes a pervasive regulatory scheme over the management of waste in Texas by providing TCEQ authority to control all aspects of the management of municipal solid waste in the state.
Mr. Steinbach,
Yeah.
I simply reviewed my prior order and I talked about that at length. What did I get wrong?
Well, I think the essential problem is that the district does not have the authority that it claims to under Chapter 36 of the Water Code. That provision gives the district authority to manage groundwater and to protect groundwater. That much is clear, but that does not extend to municipal solid waste regulation and does not overcome TCEQ's exclusive jurisdiction. This was, in fact, clarified in 2019 when the legislature amended Water Code Section 12.081, which we cited in our plea. This statute concerns TCEQ supervision of groundwater conservation districts, like the plaintiff in this case. The amendment added that TCEQ's supervisory authority over these districts includes the authority to issue a permit under the Solid Waste Disposal Act, notwithstanding a district's rule or objection. So in our view, this is a clear indication that a conservation district's rules cannot be used to intrude upon TCEQ's authority over municipal solid waste permitting. But it goes beyond that. And I don't think this aspect was addressed in the prior lawsuit either. TCEQ's authority includes the fact-finding necessary to issue a permit. As we pointed out in our reply, the commission's jurisdiction over permits includes the authority to evaluate the geology that underlies a proposed landfill. This includes the composition, the properties, the flow rate, and other qualities of any aquifer in the vicinity of a proposed landfill. So for the court to issue the requested declaration, it must first determine that the proposed landfill is over this outcrop of the Carrizo-Wilcox aquifer, but that is a geological finding within TCEQ's jurisdiction. And the issue was specifically addressed in TCEQ's final order. So simply put, this court lacks jurisdiction to intrude upon the agency's fact-finding authority on a proposed landfill. The district relies on scattered provisions of the Solid Waste Disposal Act in an attempt to show that TCEQ lacks jurisdiction, but none of these sections apply. And I won't belabor the point here. We cover it all in our reply on the jurisdictional plea. But just to highlight some of this, there's two sections, 361 and 039, that provide that, and I believe this is one that you cited in your prior order, that the Solid Waste Disposal Act provides that TCEQ's permitting authority does not limit the authority of local governments and political subdivisions under other law. That is true. But the district hasn't identified any other law that gives it authority over municipal solid waste management. And Chapter 36 simply does not suffice. It says nothing about waste management. here, the point is this: when the legislature authorizes political subdivisions to control municipal solid waste, it does so explicitly. The legislatures recognize that the construction of landfills are always contentious at the local level. And so the legislature has set up a system which limits the extent to which local governments may object. And that's in chapters 363 and 364 of the Health and Safety Code. Those chapters provide that only a municipality or a county may specify areas in which disposal of waste may not occur. But in creating these off-limits areas, the municipality or county must designate an area in which disposal of waste is not prohibited. But the district here is suggesting that the court can infer authority over solid waste management, which, by the way, appears to be unlimited, based simply on its authority over groundwater protection. That is simply far afield from the text and is contrary to the way the legislature has dealt with this issue. And I would simply point to a quote that came to mind about this from the late Justice Scalia, who once said that Congress does not hide elephants in mouse holes. Okay, well, Your Honor, in this case, the elephant is the regulation of where a landfill may be located in Texas. That cannot be hidden in the mouse hole of the district's groundwater authority. The other provisions that it cited don't apply as well. But in my view, the bigger issue here is the collateral attack issue. The requested relief is a collateral attack on TCEQ's order. The district seeks a declaration that finds that the proposed landfill is over this Carrizo-Wilcox aquifer, but TCEQ has determined that the proposed landfill is not over an aquifer, it's over the Upper Muddy Wilcox Aquitard. And these are two distinct geological formations. An agency order, as we cited in our plea, is immune from collateral attack. And this is just a quote from the Tricon tool case that we cited. It says very plainly, the doctrine of res judicata also applies to the relitigation of claims previously determined by an administrative agency. And this includes the fact finding made by an administrative agency in a final order. And we cited to a case that involved a similar situation. Fact finding made by the Railroad Commission, which could not be relitigated in a subsequent tort case. And that's the ARCLA case that we cited. The only exception to this rule is against collateral attacks is that if the agency was acting outside of its statutory authority. Otherwise, TCEQ's order is judicially binding. It's no different than a final judgment from a Guadalupe County District Court. The district's remedy is to contest this finding is to seek judicial review of that final order in Travis County District Court, which it is doing. But it cannot make a collateral attack on this finding in a separate lawsuit, which it's attempting to do here. The third issue, just briefly, the district's lawsuit is also barred by the redundant remedies doctrine. And this doctrine provides that when a statute provides a method of attacking an agency decision, the redundant remedies doctrine prohibits a declaratory judgment that would provide essentially the same relief. The Solid Waste Disposal Act provides, as I've explained, judicial review to parties affected by a TCEQ permitting decision. The district is currently, in fact, seeking judicial review. And if it prevails in its suit for judicial review, the Travis County Court may reverse and remand that decision to the agency. Thus, judicial review provides the district with the same relief that it seeks here, because it would prohibit Post Oak from disposing of waste at the proposed location by reversing the permitting decision. So their requested relief is also barred by the redundant remedies doctrine. In sum, there are three jurisdictional impediments here. Any one of these deprives the court of jurisdiction, but in my view personally, the most obvious problem here is that the suit is simply a collateral attack on TCEQ's fact finding about the proposed site. The district is not satisfied with TCEQ's geological findings that it made and is seeking a second bite at the apple from this court. This court does not have jurisdiction over this collateral attack.
Right. Thank you, sir.
Happy to answer any questions.
Your Honor, just a couple of points. Of course, an easy way for me to go forward is just to say, me too, which I do agree with everything Mr. Steinbach said, but there are a couple of points that I'd like to illuminate. The first is, in your original order, under the category or the heading of express preemption, you referred to 361.039, which, as you point out in your original order, that the text is that it does not diminish the authority of the TCEQ, the Texas Department of Health, or a local government in performing the powers, functions, and duties vested in those governmental entities by other laws. In the Solid Waste Disposal Act, governmental entities is a defined term, and the groundwater district is not a governmental entity under the Solid Waste Disposal Act. And I'm sorry if that wasn't pointed out by the original council, but it is a reality. If you look at section 361.003, subparagraph 17, a local government means a county, a municipality, or a political subdivision exercising authority granted under section 361.165. So clearly the district is not a county. It's clearly not a municipality. And to the extent subsection C might offer some relief to the district, the citation to 361.165 refers to political subdivisions with jurisdiction in 2 or more counties. So it is, the groundwater district is simply not a local government under the Solid Waste Disposal Act. So while the Solid Waste Disposal Act might not articulate exclusive jurisdiction as explicitly as we all might hope, it certainly gives all power to the TCEQ except for local governments and what we just discussed. So since the district is not a local government under the Solid Waste Disposal Act, as it pertains to the district, the TCEQ has exclusive jurisdiction over these matters. I also think when Ms. Perales was giving her preliminary remarks, she also characterized her lawsuit, or the district's lawsuit, as an interpretation of Rule 8.1 or words to that effect. But their petition is quite to the contrary. In paragraph 68 and 69 of the live petition, the district is asking this court to declare that the landfill corporation, which refers to Post Oak, cannot construct and operate its solid waste disposal landfill in the proposed location without violating the rule, the district rule 8.1. Goes on to say in paragraph 69 that it's asking this court to declare that the district, under the Uniform Declaratory Judgment Act, the district rule 8.1 prohibits the landfill corporation from operating a solid waste disposal facility and disposing of waste at its proposed site. So to my mind, it's somewhat disingenuous to say that the action here is not interfering with the express authority of the TCEQ to issue permits that allow for the construction and operation of the landfill in discussion. Finally, Mr. Steinbach referenced a change in law that occurred in the 2019 legislative session, which amended section 12.081 of the Texas Water Code, where it expressly says that the supervisory authority, which TCEQ is a supervisory authority over all groundwater districts, and the plaintiff in this case, and it says expressly in paragraph 6, well, let me read again. It says the supervision, referring to the TCEQ, over the district may include, but is not limited to, the authority to, in paragraph 6, issue a permit under Chapter 361 Health and Safety Code, notwithstanding a district's rule or objection. So the legislature has clarified the law to the extent it was unclear before, and expressly stated that the TCEQ has the authority superior to the groundwater district's rule to issue the permit that allows for construction and operation of landfill. I have focused my comments on the plea of jurisdiction, and I believe, again, the 2 points I raised hopefully will cause the court to reevaluate the prior decision on the jurisdiction of the court, which I think Mr. Steinbach has made other points that we also expressed in our brief, in our original answer. Ms. Waddell would address the issue regarding the aquitard and the fact finding by the TCEQ and the SOA administrative law judges that to the extent the district's rule applies, it refers to a geological feature of an aquifer and the outcrop of the aquifer. The TCEQ's finding is that The landfill location is over in Aquatard, a different geological feature. But again, I would defer to Ms. Waddell to address the specifics of the facts as pertains to the motion for partial summary judgment.
All right, Ms. Waddell.
I'm sorry. Yes, I think Ms. Perales stated it accurately in that sort of both pleadings are inextricably linked together. And so for the sake of not repeating too much, when it comes to the motion for summary judgment, you asked again to the overarching issue of what's different here. And what's different here from the prior proceeding is there's certainly a fact issue when it comes to the location of the landfill and whether it is over the difference of an aquifer versus an aquatard. And again, going back to Mr. Steinbach's arguments, you have two triers of fact, really. You have the SOA, ALJs, and you have the TCEQ commissioner finding of fact, which is different from a conclusion of law, that the landfill is located over an aquatard versus an aquifer. And that's a finding that the district is disputing as well. And so the motion for some partial motion for summary judgment, a core element of that is having to agree that with the district that the landfill is located over an aquifer, and that is very much a fact issue, an issue that's been decided adversely to the district by TCEQ already, and in an order that is again pending on appeal in a separate matter. And so these two are inextricably linked, but when it comes to the MSJ alone, there is a fact issue then that needs to be determined if that is a central core claim to the district's motion.
Is that all you have on that?
Yeah.
All
Yes,
right.
we have there's objections to evidence, but we can delve into that if you'd like. But those are the that is the central overarching issue.
I'm looking at the findings of fact of the hearing officer. Can you tell me which one makes the finding regarding the aquatard?
The findings regarding the aquatard are at, let me get the exact numbers so we don't throw it off. I believe it's 271 and 101. 101 and 271.
Can you tell me what an aquatard is? I've never heard that phrase before.
Yes, I can give you the non-expert definition of an aquatard. They are essentially different in permeability, which is important obviously here too when you're discussing what's to be cited over land. I should know I do have a degree in civil engineering and some hydrology course experience, but it's not been used in a while. But the TCEQ rules do have a definition for an aquifer, and I believe this is cited in TCEQ's response as well to the MSJ, and that is a geological formation, group of formations, or portion of a formation capable of yielding significant quantities of groundwater to wells or springs.
Probably need to be slower for our court reporter, if you don't mind.
Oh, so sorry. And then the aquatard, again, this is also quoted in TCEQ's response. So please correct me if I'm wrong, Mr. Steinbach, but an aquatard is a geologic formation of low hydraulic conductivity, typically saturated, but yielding a limited amount of water to wells. And so they're geologically different, and those differences are significant. And I think TCEQ can elaborate on this further, but and this was an issue in the proceeding that was litigated and discussed amongst experts, including the district. All these parties participated in that particular fact issue. And so the TCEQ order does make the findings regarding an aquatard versus an aquifer. And again, those issues are in dispute and on appeal by the district. And I should add, just to illuminate, those aren't the only findings of fact that the district has appealed from the TCEQ order.
All right, Ms. Perales, would you like to respond?
Yes, Your Honor. First, with regard to the jurisdictional arguments, I don't think that that either party has presented this court with any argument that makes this case different than the prior case in terms of whether the court has jurisdiction to determine the preemption issue. What Post Oak and TCEQ are arguing is that TCEQ is the only entity that gets to decide whether the Post Oak landfill can be sited at the proposed location. That's their argument. Even if all the parties, even if TCEQ, Post Oak, and the groundwater district all agreed that the landfill's location is on the outcrop of the Wilcox Aquifer recharge, Post Oak and TCEQ would still be before Your Honor arguing that if the TCEQ issued a landfill permit anyway, that would be the end of the story, because the TCEQ's landfill permitting authority preempts the district from enforcing its Rule 8.1. And in fact, in many ways, that is what occurred in this case. While there are some specific findings that TCEQ and Post Oak have pointed to in the TCEQ order, findings that relate to the TCEQ solid waste regulations and whether the application satisfied those solid waste regulations, the TCEQ also included findings stating that the application accurately identified the regional aquifer. And if you look at what the application says in terms of identifying the regional aquifer, it says this is located on the Carrizo Wilcox. That is a statement that is repeated in the Post Oaks application that was submitted to TCEQ, sealed by their geologist, adopted by the geologist when he took the stand and offered sworn testimony. It's included in various figures that are included in the application, identifying the landfill site over the regional aquifer of the Carrizo Wilcox. The fact finding that they're focusing on is a fact finding related to TCEQ's landfill permitting regulations with regard to characterizing the subsurface and how the subsurface is supposed to be characterized under the TCEQ's landfill permitting authority. The TCEQ's fact finding has no bearing on how the Texas Water Development Board identifies the regional aquifer or delineates the boundaries of the regional aquifer. The TCEQ fact finding has no bearing on how the Bureau of Economic Geology delineates the regional aquifer. And our contention is that it has no bearing on how the groundwater district delineates and determines the boundaries of the regional aquifer under its jurisdiction. And so that our contention is that the final order of the TCEQ and the fact findings that have been focused on by the parties are a red herring in terms of the jurisdictional arguments. The arguments that have been presented remain preemption arguments. The case is cited by the TCEQ in their reply to the response to the pleas to the jurisdiction are not analogous here. Those cases did not involve two different governing entities, two different governmental bodies with regulatory authority who are both attempting to enforce that regulatory authority. The cases that are most analogous are the ones that Your Honor cited in your last order, the Southern Crushed Concrete and the BCCA versus City of Houston cases. Those cases involved a local government attempting to enforce an ordinance and a claim that the TCEQ's Texas Clean Air Act preempted those local governments from enforcing their local ordinances.
Mr. Riley said that the authority is not a governmental entity under the Solid Waste Disposal Act, Chapter 361. Is that correct?
I think that one could read the Solid Waste Disposal Act definitions in a way that would include the district or would not include the district. But the point is that the Solid Waste Disposal Act is not a preemptive statute. It's not a preemption act like the Clean Air Act. Whether the district is included or not, the point is that the Solid Waste Disposal Act very expressly and explicitly recognizes that other governmental bodies, whether you include the district or not in that definition, other governmental bodies have concurrent jurisdiction. Therefore, the Solid Waste Disposal Act, unlike the Clean Air Act, does not expressly state that it is preempting any other governing body. This is also reflected in the permit provisions themselves. I mean, the permit that was issued by the TCEQ includes a permit provision that says this is subject to other governing bodies authorizations. That includes federal authorizations, local authorizations. It doesn't specify which governing bodies. It just says you got to still comply with other governing bodies that have jurisdiction and whose authorizations are necessary before you move forward. All of this reflects that, unlike the Clean Air Act, the Solid Waste Disposal Act clearly recognizes, contemplates that it is not the final say, that it does not preempt all other authorities, that it recognizes that there are some other authorities with jurisdiction that apply. I think the other arguments that have been raised, the collateral attack, the redundant remedies, those arguments would only work here if one were to interpret the Groundwater District's petition and its claims as an administrative appeal. But that's not what we have here. What we have here is a declaratory judgment regarding the district's rule. Separately, the district.
That raises my next question.
Okay.
Let's assume for sake of argument that you prevail in this hearing and I deny the police's jurisdiction, grant the summary judgment. Your district is entitled to enforce the rule. What's the remedy for the district? What do they do then? Do they fine them $100 or what?
Well, what would happen is that if the Post Oak were to move forward and were to start applying waste in the landfill, then it would be a violation of the rule if they didn't somehow seek permission from the district first. Some sort of, I don't know, some sort of variance. I'm not sure what the procedure would be.
What are you saying? You'd seek injunctive relief at that point?
It could avail itself of all of the remedies allowed under law, which includes injunctive relief, which includes implementing fines and declaratory relief.
Go ahead.
I might have lost my train of thought.
My fault. I'm sorry.
No, that's fine. I think I was making the comment that the redundant remedies and the collateral attack arguments would only apply if this lawsuit were seeking review of the TCEQ's final decision or its permit. To the contrary, the district is saying that the TCEQ's final order, the TCEQ's permit, has no relevance to the groundwater district's rule. The groundwater district has its own separate authority to enforce its rule, irregardless of whatever the TCEQ determines with regard to its own solid waste permitting rules. This is consistent, actually, with the position that the TCEQ has taken in a response to comments, which is one of the exhibits that we attached to our response to police to the jurisdiction, wherein the TCEQ said, we have no jurisdiction to evaluate the groundwater district's rules and how those rules might apply here. And that response to comment was in fact codified by the by section 12.081 that TCEQ and Post Oak both cite to. In other words, the legislature's recently enacted statute 12.081, it supports our argument. It codifies what we already knew to be the case. And that is that when TCEQ determines whether its landfill permitting regulations have been addressed by the permit applicant, it is not considering the groundwater district's rules, the groundwater district's authority, or the groundwater district's jurisdiction, because the TCEQ does not have jurisdiction to do so. So the case that we're presenting to your honor today is a preemption case. And there aren't competing motion for partial summary judgment. There's only motion for partial summary judgment. That's one difference from the last case. And our motion for partial summary judgment is seeking a declaration of the rights of the parties under Rule 8.1, not anything about not seeking a collateral attack or anything to do with the TCEQ's final order on the landfill permit. We're not even challenging or making any arguments with regard to the fact findings by the TCEQ. What we're saying is that under our rules, under the district's Rule 8.1, the district has the authority to interpret what an aquifer is, consistent with the Water Development Board, consistent with the Bureau of Economic Geology, consistent with statements made in Post Oak's own application. And in interpreting its rule of the aquifer boundaries, the district is seeking a declaration that that Post Oak may not accept waste at the site of its proposed landfill. Again, this court must take jurisdiction in order to reach that issue because it is a preemption issue. I think we have briefed the preemption arguments both in the prior case and in our pleadings in this case. And unless there are specific questions, I won't get into those arguments other than to, again, emphasize that the point of referencing the various statutes in the Solid Waste Disposal Act is not to find one specific statute that says groundwater district rules must be acknowledged and enforced by the TCEQ. We already know that TCEQ doesn't acknowledge or enforce groundwater district rules. Rather, the point of citing to the various provisions in the Solid Waste Disposal Act is to compare and contrast it to the Texas Clean Air Act. The Solid Waste Disposal Act recognizes that there are various other governmental entities with jurisdiction that might affect its landfill permitting authority. The Texas Clean Air Act recognizes that there are no other governmental entities that can enact any provision that is inconsistent with the Texas Clean Air Act. That difference makes it clear that preemption does not apply with regard to the Solid Waste Disposal Act. With that, I'm happy to take any other questions.
All right, thank you, ma'am. Mr. Steinbach, do you want to respond?
Yes, Your Honor.
Briefly, please.
Go ahead.
Briefly, please.
Yes, sir. Yes, sir. Yes, Your Honor. First of all, I don't know why we're talking about preemption. We have not pled preemption. The district can't transform our plea into one based on preemption. We have presented a narrowly tailored objection based on exclusive jurisdiction and the rule against collateral attacks. Preemption. I'm sorry.
Doesn't that presume preemption? I mean,
no, it doesn't. Preemption.
If TCEQ doesn't have, if all the other agencies aren't preempted, how can you object to another agency taking some action in this case? I don't understand.
Well, we're not taking a position on whether the rule itself can never be applied, but I guess what we're doing is an as applied sort of challenge here. We're not attacking the rule itself. It may well be.
It could never be applied to a TCEQ order.
Well, to a site that is subject to a TCEQ permit proceeding. That's what we're arguing.
So why is that not preemption?
Well, because we're not arguing that the rule itself is invalid for any instance. The problem here is that the site is subject to a TCEQ permit proceeding. We're not challenging the rule.
Let me rephrase the question. Can you imagine a circumstance where this rule could be applied to a TCEQ final order?
Well, that's our case, but a preemption case would be to say it's per se invalid, regardless of whether there's a TCEQ permit proceeding going on for the same site. That, to me, that's the difference.
I think you're trying to figure out how many angels can dance on the head of a pin. It's a distinction without a difference, as I see it.
Your Honor, may I respond to that?
Yes.
I think you asked for scenarios. The application of this rule to a landfill permit could be applied to a dumpster. could be applied to a garbage can. The rule is so general that a landfill is not, it's not just a hole in the ground. It's a highly engineered containment system that prohibits or prevents the waste from actually leaving the impoundment. So if it applies to a landfill, it applies to your garbage can. It applies to a dumpster behind a restaurant. It is the district that has extended the application of the rule, as Mr. Steinbach was saying, to a landfill, which is the exclusive authority and under the exclusive jurisdiction of the TCEQ to authorize.
So it is preempted then.
Well, as applied, and it's exclusive jurisdiction in the TCEQ to issue the authorization that the pleading of the district is for you to decide that the groundwater district can essentially usurp the authority of the TCEQ. And that's where the jurisdictional argument lies. As you referred to, and Ms. Perales argued, the Clean Air Act is totally different. That's not true. The Solid Waste Disposal Act gives exclusive jurisdiction and authority to TCEQ or local governments that follow certain rules, that there's not totally open to local governments. The local governments of the municipalities and counties and political subdivisions with jurisdiction of more than one county, but none of which, again, the groundwater district isn't a local government under the Solid Waste Disposal Act. The authority of the local governments are preserved in the Solid Waste Disposal Act and defined in the Solid Waste Disposal Act, especially and particularly with regard to prohibitions, prohibition on the siting of landfills. So there's more specific references in the Solid Waste Disposal Act that Ms. Perales is glazing over by simply saying we're a local government with independent authority, and so we can adopt a rule and then apply it as we see fit to various scenarios, including where the TCEQ has issued an authorization. And again, I think the recent enactment by the legislature that says explicitly that the TCEQ has supervisory authority over the groundwater districts, that's not new. The Texas Water Development Board doesn't have supervisory authority over groundwater districts. The Bureau of Economic Geology doesn't have supervisory authority over groundwater districts. The TCEQ does. And the TCEQ has explicit authority under the new statute we referenced to issue permits, whether the district has a rule or not. And I think that is new information for Your Honor, in addition to the point about the local governments that wasn't considered in your original opinion. But there is no difference ultimately between the Clean Air Act and the Solid Waste Disposal Act. And what Mr. Steinbach started out with, there's nothing in the groundwater district's authorization that says it has jurisdiction over solid waste disposal. It would be an odd situation at best to say that a groundwater district without jurisdiction, with jurisdiction only in one county, has greater authority than a municipality, has greater authority than a county, has greater authority than districts with jurisdiction in more than one county. It would swallow the TCEQ's authority if Ms. Perales's position is accepted.
Your Honor, may I finish?
Yes.
Yeah.
Are you done, Mr. Riley?
Yes, Your Honor. Thank you.
Okay, thank you, Your Honor. Just to respond to a couple of other things, I think essentially there's really two issues in this case. And I think this would help clarify how to proceed on this. We have the issue about the geology underlying the site. The district thinks it is a aquifer. TCEQ found that it's this aquitar. But then separate from that, we have the issue of the district's rule and whether that rule, the attempt to apply that rule in this case would interfere with TCEQ's authority. It's our position that that's an exclusive jurisdiction problem. The district thinks that it's a preemption problem. But my point here is the court doesn't need to even reach that second issue, because what we have here is the problem is the TCEQ has already made a fact finding here that cannot be collaterally attacked. And this is precisely the situation where the rule against collateral attacks applies. It doesn't apply, what the district said doesn't make sense, that it would apply in a suit for judicial review. That is precisely the vehicle that one would attack a finding an agency has made. What you can't do is file a lawsuit separate from judicial review in another county seeking different fact finding. TCEQ has made this fact finding. Its fact finding is equivalent to a final judgment. They have to appeal that judgment through, or that order through, the process the legislature has provided. So this collateral attack issue is dispositive, and it does apply here. Also, I wanted to also mention the city of Bellevue case that I think was cited in the briefing and in your previous consideration of this case. It doesn't apply. First of all, we maintain our position that our plea is based on exclusive jurisdiction, and that is a clear basis for a plea to the jurisdiction. We are not required to couch this plea in terms of a preemption argument. We can bring it as exclusive jurisdiction. There's plenty of cases where courts have dismissed on that basis, but the facts are distinguishable. So even if that case applied, it's distinguishable. The issue in that case was whether a city's ordinances that regulated drilling into a salt dome, if I remember correctly, were preempted. And that did not involve a declaratory judgment that depended on fact finding committed to an agency's jurisdiction. I mean, that's the clear difference in the situation here. That was just a straight up, is this ordinance preempted or not? It also did not involve a political subdivision that lacks authority to regulate the contested matter under its enabling statute. I mean, this political subdivision is a very different creature from a city. And I don't know if the city in that case was a home rule city, but if it was, they certainly have powers that are more expansive than a political subdivision like the district with certain defined powers, and which do not include, as we pointed out, any authority over solid waste management. And then finally, it does not involve a permitting matter that the legislature has expressly exempted from local control under that section of the water code that we've been cited. So it's a completely different situation here. And I think it's really mostly hinges upon the fact that TCEQ has made findings that are contrary to the findings that the district seeks from this court.
All right. Mr. Riley, do you have anything else?
I have one more comment, Your Honor, if you allow me. The nature of this action is a declaratory judgment action. And you asked Ms. Perales a little while ago, what would the district do? Well, I think it's a very insightful question, because why isn't the district, if it's so certain of its authority and jurisdiction, why are we in a declaratory judgment? Why isn't it pursuing an injunction? Why isn't it taking the action that it says it has authority to take? It's asking you for essentially an advisory opinion here and couched it as a declaratory judgment, which I think is an improper mechanism. If it has the authority to enjoin the construction and operation of landfill, that's its remedy, not a declaratory judgment action. Again, that's not to give up on the jurisdictional arguments or other arguments that have been made, but I think it's at least worth noting that the district is not taking the action it says it has authority to take. It's asking you, Your Honor, to give it the authority. And I thank you for your time.
All right, thank you. Any last word, Ms. Perales? I'll give you the last one.
Thank you, Your Honor. I will address that last issue first. The motion that's pending before you is a motion for partial summary judgment. To date, the Post Oak landfill has not accepted waste, so it has not yet violated the district's Rule 8.1. If the district were to determine that a violation had occurred, it could employ all of the remedies available to it, including declaratory relief. It is not unusual, and in fact, it is the very purpose of the Declaratory Judgment Act to declare the rights of the parties before a violation has occurred. And that is what the district is attempting to do by its lawsuit here today. Other than that, I would again note that TCEQ did not cite Southern Crushed Concrete nor the BCCA versus City of Houston cases, even though those cases are the most analogous to the case that's pending before you today in terms of the procedural posture that's presented. That is whether the TCEQ, its regulatory authority preempts a local governing body from attempting to enforce similar rules. The cases that have been cited by TCEQ in their briefs are not applicable to the case presented here today. And finally, I would point to the motion for partial summary judgment evidence exhibit 5, which is included with our motion for partial summary judgment. And that is a copy of the permit that was issued by TCEQ And there is a provision in that permit that explicitly states that the permittee Post Oak shall comply with all applicable federal, state, and local regulations and shall obtain any and all other required permits prior to beginning any on-site improvements or construction approved by this permit. And then the TCEQ's response to comments, which is an exhibit that was included with the plaintiff's response to plea to the jurisdiction, where it says that the groundwater district's rule 8.1 has not been incorporated into the TCEQ rules. And so the commission, the TCEQ, is not authorized to determine whether the landfill would violate that rule. This is consistent with the statute that was recently passed by the legislature, 12.081, that recognizes that the TCEQ's jurisdiction is also limited. It is limited to landfill permitting, and it does not have the authority to construct or determine the groundwater district's rule. In fact, the permit is a negative pronouncement. A permit by the TCEQ grants no affirmative rights to the permittee. It merely removes the government-imposed barrier to the particular activity. And that is a statement from the Texas Supreme Court and FPL Farming Limited versus Environmental Processing Systems LC. And that's what we have here. And
All right. Thank you all very much. Couple of things, just my schedule. I'm tied up with hearings and various other things this week and next, so I probably won't get a chance to issue anything before the week after next. I will rule by in writing to the various, with copies to each of you. Now, I have received from Ms. Perales copies of their pleadings and briefing. I don't think I've gotten anything from TCEQ or from you, Mr. Riley. I've got copies of the statutes from you, Mr. Steinbach, but but I have not gotten copies of your brief or so if you have a brief or a motion you want me to read, please furnish it to me at my personal email, the Gmail account, which I presume you all have, and that'll give me an opportunity to read it. I don't have easy access to the district court files.
Understandable, Your Honor. We'll be happy to do that, of course.
All right.
Your Honor, I had one question. We have a proposed order. Can we send that to you as well?
You may if you choose. I don't require that. I know some district courts do. Typically I'll either prepare an order myself or I will ask the prevailing party to prepare one after I rule.
Okay, thank you.
That's my practice. All right. Do we have anything else then?